ground and basis for appearing at that protest. My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given. My Lord, hearing for today, direction for today's hearing can be given.
My Lord, before Mr. Kibe moves on that file.
2024, before the bench. Will take forums of the files which are before the court and that you can raise any issue?
My Lords, may you kindly equally confirm whether E0, E5 or 9, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
My Lord, so my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether you can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mamuye, who gave directions that it will come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. And a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. Raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy, one with the second petitioner, and we were seeking clarifications with regard to directions on that file, because as we can see, the files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, your ladyship, we heard the court assistant call out petition E13 for 2024, and she mentioned the word Gachagua. That is the file that was called. And in order for the record of this code to be systematically accurate and easy to follow, may I, with respect, ask that we get clarity on this file that was called out, E13/24 of Gachagua, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court. This
Senior Counsel Paul Newton, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Gachagua before it arrived here with E0114. 011414. Then we have application number E0115, also from Gachagua. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable Chief Justice has constituted this bench for hearing and determination. There are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given direction pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we well guided, and perhaps also for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Gachagua is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Gachagua, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? Just confirm on the question of the integration of that file in the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Gachagua or in Nairobi?
Let me deal with that. My Lord, for the purpose of A572 of 2024.
That file is not before us.
That's all I'm only saying. I have had the directions of the bench. The file is not before you.
Welcome to QNet's world of new beginnings, where every sunrise is a promise of our commitment.
The same day, the Kerugoya file was filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours are borders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lord. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari,
Yes, my lord.
the file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has had me loud and clear. Thank you.
If you could more elsewhere. I had indicated this honorable court that there will be at least 3 clarifications.
Just a minute to something.
Yes, madam.
Now, I think we need to get something right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that they are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why we're here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
Just a minute, please.
Perhaps just to add that it's the numerous other petitions that are coming up.
Yes, my Lord, I believe now I can be able to make the clarifications. We are starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first. There's a quorum in E013, which was consolidated in Kerguelen with E014. Just take quorum on that file.
Your Lordship is terribly something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, E13 was not part of what was called. I've not heard it, perhaps it will be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated. Let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The direction from this court were very specific on 3 different files.
My lords, I'm well guided, but when Justice Mrima was giving the clarification, I never heard him clarify whether the Keroboya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Keroboya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
My Lord, may I say something?
Let me answer you. You said that record speak for himself. And for record, matters which came from Keroboya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Keroboya was already consolidated. Those proceedings which took place in Keroboya consolidated these 2 files. So let that not be an issue here, please. On the directions issues on 11 by Judge Richard Mongo, these were the directions. the petitioner in E-014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E-013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to the Chief Justice forthwith, the parties' response to the amended petition and petition E-013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E-014, and petition number E-013 are hereby consolidated. The parties who appeared before the Kerugoya court in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we will now raise the issues that you want to raise, particularly arising from the issues in Kerugoya. And I do not
will then proceed and take forum on it. They were consolidated, so we don't take further forum on this matter.
The Attorney General, I don't know, I had indicated to the court earlier, I need to raise some clarifications.
Section 7 of the Attorney General's Act.
You had read your subject to speak. It doesn't override my right to represent my clients.
I'm repeating it.
Can she then say her piece? I say mine.
Which matter are we now dealing with?
We have 0115.
We have
0115.
My Lord, I wanted to say that
Yes.
the only matters before this court are the matters which had ex parte orders. The matters that came from Kerugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders.
I think they do.
We have E15.
E15 has
Conservatory orders, but E13 and E14, although from Balindiway, they were filed before impeachment and they had no conservatory orders.
I hope I can then be heard without further interferences. My Lord,
which is the matter, Mr. Paybill?
My Lord, I'm leading the number of advocates in this matter from Kirinyaga, E015.
Kerugoya 15.
Yes, Kerugoya 15.
Yes.
Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice, which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on record. We do not trust that the Honorable Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice William, the Deputy Chief Justice. Lady, my lords, arising from that are one, a legal issue and a matter of Article 150. My lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We would be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may
I think I have a right to raise those issues. I have a right to respond.
Just give fellow Mungai time.
Mungai, Muigai.
I just wanted for good order, my Lord.
Is that a clarification, Mungai?
My Lord, I am Mungai. I believe he will speak in response as soon as I'm done. Let me finish.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Muigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and as the court, I should be heard in silence. He will respond. And I indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would seek on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My Lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My Lord, under the former constitution, my Lord, under the former constitution, we used to have a practice in which we had unofficially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But not because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on a Saturday. And my Lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My Lord, for purposes of Article 165, I believe it's 4 of the Constitution, The powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must